everyone, this is Arkady Frekhtman, a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, in this episode. So we are about 7 days from being current, and we're going to go to the next question in the list, and it's from an Amanda Lynn Gibson, and she says, "You are a superhero." Well, thank you. I found YouTube to be a source of great information about post-concussion syndrome and traumatic brain injury, TBI. Yet professionals and their staff remain ignorant about the special needs of TBI-affected people. Just a few minutes could educate them to the invisible disability of TBI. I am not in a wheelchair, nor do I have a cane. I am not bald from chemo, but my challenges are real. Every TBI is different. And she says, you should start by slowing down your talking. Do not have multiple conversations going. Ask what has been understood so far. I may not even realize that I don't understand, and I don't know what I don't know. Be flexible and accommodate the person. Each moment and each day can be different. Lower the noise, the lights, minimize the distractions and the superfluous activity. Be patient, be compassionate. Do not be patronizing. When a TBI person gets flooded, we shut down or lash out or just cry. The head hurts, vertigo, nausea, blurry in and out. If you can't deal with this, stick to neck and spine cases. It was easy to make this list. The attorney that she has did none of these things. They should not be allowed to handle brain injury cases because the brain injury victims require special understanding. And she feels that her attorney abused his position and her disability. And it may be too late to unsign, but it was wrong and should not happen again. Yeah, I mean, that's terrible what happened. I mean, absolutely, I agree with her. And those are some of the symptoms of traumatic brain injury. So it's really important for an attorney to be able to, we kind of sometimes utilize checklists, and there are certain checklists that are used by different organizations. You can create your own of symptoms, and that helps you to identify if a case has a potential to be a brain injury case. And I was actually watching a continuing legal education today from a doctor, and he was saying that he was actually showing medical records on the screen, and he was saying, look, here's, for example, somebody who comes into a doctor's office and he's complaining about, memory loss, difficulty concentrating, all of these symptoms of brain injury. And then the final diagnosis, he was showing the final diagnosis, none of that. The final diagnosis is sprain and strain. How come? How come this doctor is not listening to the patient's symptoms and diagnosing the brain injury? And he said brain injury is one of the most undiagnosed or misdiagnosed injuries. And I think the reason is because maybe this particular doctor was more of a chiropractor or maybe a pain management doctor. Maybe they're not qualified to diagnose brain injury. Maybe they weren't looking for brain injury because, if I'm a specialist in, let's say, chiropractic, you come to me, I'm going to diagnose you with chiropractic. It's just like if you go see a plumber, they're going to talk about plumbing. They're not going to talk about dentistry. They don't know anything about dentistry. They're a plumber. It's the same kind of thing. But I mean, in medicine, it should be a little bit more holistic, or at least we should hope that it can be a little bit more holistic, and or maybe getting all the specialists together or referring to the right specialist. But I think with traumatic brain injury, it's really important to be able to send a client to almost like a neurologist who could be a quarterback. It doesn't necessarily have to be a neurologist. Sometimes it's a physiatrist, but somebody who's familiar with brain injury could be a quarterback and then send them to other specialists and really develop the overall diagnosis and treatment of the patient. And she says that TBI affected people should have an advocate for all their interactions with the legal and medical professionals. So she's just, I guess she's upset about what happened to her. So I'm sorry to hear that. And the other thing she talks about is the fact that, and something I say, a lot also in my videos, is that an attorney should be like a guide, right? Your advocate, your guide, and kind of help you through the dark woods, because it is kind of complicated, the whole legal process. Even if you're not a TBI victim, right? But if you're a TBI victim, it's even more complicated. So it's almost like you have somebody hold your hand and lead you through the dark woods. and she feels like her attorney took advantage of her mental fogginess and TBI problems, and then kind of forced her to take a low settlement, 3 years, and they delayed the trial 3 times. And so that's, I'm sorry to hear that happen, but I think that, that's important. That's an important lesson. Even if she can't undo her settlement, that's an important lesson for other people, that, you really need to be with a TBI attorney and be able to examine all of the aspects and get a fair settlement. You don't want to settle the case for too low. And, I was actually doing a lot of consults too with different people from all over the country, people who text me from the YouTube channel. And I thought maybe an interesting video would be to go back over my notes from some of the consults and talk about some of the issues that I see. Not anything specific to their case or to, talk about any confidences, but maybe just generally to talk about some of the issues, because there are a lot of interesting issues that maybe we could bring to light on the channel that I've learned just from talking to different people. One of the issues is that a lot of lawyers just don't want to answer people's questions, don't want to spend time with the client, and also don't even bother to find out what the full insurance limits are, which is really kind of like mind-boggling, because they'd want to know that, because then they could get more money for the client, but for whatever reason they don't want to find that out. And I keep seeing that over and over again, people saying that my attorney doesn't know the limits, and that's just mind-boggling. Okay. And we have Thin Line, who says, I was working out at a gym about a month ago and the cable snapped. Instantly knocked me out. I woke up I woke up to my watch dialing 911. I couldn't move for 10 minutes. I was a bit confused and laid there. After 20 minutes, I got up. And he feels like the people need to be held accountable. He has pictures. He left the gym confused, probably has a concussion. He called his lawyer and needs to address what's next. And then, it sounds like it could be a TBI as well. It could be a traumatic brain injury, potentially. So it's hard to say, but definitely sounds like it could be a liability case as well. If the cable just snapped, it could have been something wrong with it that they should have known and fixed and failed to fix. You'd have to do a little bit of a deeper dive to figure it out, but definitely sounds like it could be negligence. Then Gloria Fonseca says, thanks for all the info. And I really enjoy your videos. Very informative. Thank you so much. And then we have Curtis Lawson. I had a trip and fall injury at my condo complex 7 weeks ago and fractured my spine. This has been going on for 7 weeks of horrible pain, and today I just had surgery. So far, I've spent about 10 days in the hospital just for pain management. And when I call my lawyer, I get a secretary. I'll have to have them call you back, but she never does. So I'm just saying of going with somebody else after I've signed with him. How long should I give him? A week, 2 weeks, to reasonable time before I look for somebody else? Yeah, I mean, there's no real time limit. It's whatever you feel. Just like we gave the example of somebody being your guide and being your advocate. If you feel like they're not your advocate, if the secretary is the only person you could ever talk to and they're just kind of brushing you off and it's been weeks on end, you might want to consult with somebody else. But if the lawyer maybe was just busy, or maybe they were ill, and maybe now they're back in touch with you, then you can of course continue with that lawyer. So it just depends on the specific circumstances. But ultimately it's your choice, because you're the client, right? That's what you have to remember. You're the one with all the power. You choose the lawyer. You choose how many lawyers. You can have more than one lawyer. You can have one lawyer, and you can choose when to switch them. It's ultimately you're in control, because you're the client. Okay, and then Mike Richards says, I have a question. If a person has undergone traumatic brain injury in a personal injury accident, does the insurance company or their lawyer send the TBI person to their own doctor to be tested for memory loss? If so, are they trying to see if it's permanent injury, or is it to establish a case of no liability? Yeah, I mean, usually what the insurance company will do is they will send you to their doctor. Now, in a traumatic brain injury case, they could send you to their neurologist, or if it's a more in-depth case, They could even send you to their neuropsychologist, and the neuropsychologist could do like a whole battery of tests, like for example, your ability to add things, remember things, and then they will write a report. And I've seen all types of reports. Like sometimes a neurologist will just say, you know what, there's no brain injury, but how would the neurologist know? And if you have a more developed case, let's say you have your own neurologist, you have your own neuroimaging, like a diffuse tensor imaging or 3T MRI, and you also have your own neuropsychologist, then what they might do is send you to their neuropsychologist, and their neuropsychologist might say, oh, I spent like hours with them, and they're like a malingerer, they're faking. So usually the defense doctor is not independent in the sense that they're truly an independent doctor that's examining a patient to try to independently see, hey, is this an injury or is this, not an injury? It's really like their hired gun, and then that hired gun is going to say what they want them to say because they're the ones hiring the doctor, they're the ones paying the doctor. So almost always that doctor will reach the same conclusion. So yeah, be careful with that. But what I like to do is I like to send someone with the patient, almost like an IME watchdog, and they're in there and they're watching everything and they're taking notes, because sometimes these doctors will come and they'll say, hey, my exam was like 2 hours, but in reality the exam was like 10 minutes. So you want to have that documented. Sometimes you could videotape the exam, so if you can videotape it, you should. But some states don't allow it. Like in New York, I don't believe they allow videotaping or audio taping. So you have to send somebody. You have to send like a watchdog, an independent witness, and then the independent witness can come to court and testify. Okay, the next question is from Yadi Ramirez. Are you allowed to get a second opinion from another doctor, even if your case is still open? Yeah, absolutely. I mean, if it's just like a treating doctor, like you have an injury, and you have a treating doctor, let's say it's orthopedist, right? Or it could be a spine doctor. If it's like a herniated disc and you're not happy with the doctor, or for whatever reason you want to get a second opinion, you can absolutely do that. There's no problem with that. It would just be a treating doctor. Let me see what else. And then someone says, hello, sir, can you do one explaining a tort? Yeah, I mean, a tort is just really basic. That's just like tort law is personal injury law, which is basically, a tort is just basically civil wrong. So it just means that, at the heart of it was someone using reasonable care, right? Reasonable care and ordinary care. And if they weren't using reasonable care, then they can be negligent. And if they are negligent, then did that negligence, what they did wrong, did that cause your injury? If it caused your injury, then they're liable for the tort. So it's just like an overall, there's tort law, and tort law in law school, you take torts. And what they do there is they talk about everything. They talk about personal injury, they talk about dog bites, they could talk about nuisances, they could talk about, like for example, somebody has, a farm and the neighbor is like leaking some kind of noxious or bad gas into the farm and the animals are dying. There's so many different types of torts, but tort just is really like a civil wrong. So it's a very general question, but yeah, absolutely. We could look into that a little bit more, maybe do a video about it to talk about the common types of torts. I can outline a video if people are interested in that, but it's the same as personal injury, basically. Okay. And then Ray says, I need a damn new lawyer. My lawyer told me that he didn't send a written statement asking for their policy limits. He said he trusted the defense, and now they're saying they may not have a corporation policy. So I'm pissed. I need help. I'm firing. Yeah, no, I'm sorry to hear that. See, that's one of the things. You can't really trust the defendants. Like, that's one thing I learned. You really have to be able to, you could trust, but you have to verify. You know what I mean? You trust them. You don't want to be like some kind of, all insurance companies are evil, all defense lawyers are evil, because then, you need to have a working relationship with people. So you want to give them the benefit of the doubt. You want to be trusting, but you have to verify, right? So you say, look, I trust you, but here, there's a court order, tell me all your insurance. Is it $1 million? Is it whatever it is? And then you get the policy, you review it, and then is there excess, is there umbrella? So you trust but verify. You can't just blindly trust them. I'm surprised a lawyer would do that. Just blindly trust them. They could say, hey, we have $10 million, and at the end be like, oh, you know what, we have 25,000. And then, you know, it's just completely ridiculous. You can't do that. Okay. The H. Chambers says, great video as usual. I have a question. I'm working on a workers' comp due to a third-party premises injury. What does it take for the third-party homeowner insurance to include their umbrella insurance? Is it after the basic policy limits are exhausted? Thanks so much. No, it doesn't necessarily mean. I mean, umbrella. Yeah, you have to exhaust you have to exhaust the first layer. So, for example, if you have, let's say, a premises, right, and you have like $1 million, but then you have a $5 million excess. So, yeah, you would have to, in order to touch the excess, you'd have to get the first million first, right, because that's the primary policy. Once that's tendered, meaning once they've paid the million, then the next dollar, the $1,000,001, the first dollar after the million would come from the excess or the umbrella, the next policy. So that's usually how it works. But to find out what it is, you don't have to, wait. You can find out everything. Just send a demand and you say, look, what's your insurance? And they have to tell you all their insurance right up front. In New York, they have to tell us even without a court order. I mean, I'm not sure actually about premises cases, maybe not in premises, but in auto cases, there's insurance law 3420F. So we send the initial letter of representation just saying, hello, we're, Frekhtman Associates, we represent Mr. Smith or Mrs. Smith. Tell us all your insurance limits. The auto carrier has to tell you. I mean, they don't usually tell you the excess, but you can get that in a court order later. And then there's a video I talked about a multi-million-dollar verdict in a slip and fall case. And then somebody asks, will such a large verdict be appealed? It's definitely possible it could be appealed. I mean, some verdicts do get appealed, especially large verdicts. So most likely. Let's see what other questions we have. Okay, Philip Satil says, when does your attorney let you know how much he's suing for and what his strategy is and the strength of your case? So I guess it's like a lot of different, questions there. It's a short question, but it's a good question because it has a lot of different questions. So, I mean, I think the first thing he should let you know probably is like the strength of your case. They can get a sense of that even upon intake. Or if they feel that the case is missing some, let's say it has some holes, but maybe the holes could be filled in. Like, for example, you don't have enough medical treatment, but you can get the medical treatment, or you haven't done a surgery that the doctor says you need, but you can get the surgery. So you could fix what's not strong in the case and make it stronger. So you could do that as an attorney. So the strength of the case is something you could assess and you could develop as you're handling it. Now, how much he's suing for, it doesn't really matter because that's really a decision you have to make with the attorney. You could sue for like anything. You could sue for, like, some states allow you to put in the complaint, I'm suing for 10 million or 100 million. But in reality, what the case will actually settle for and what you actually receive will be the amount that the defendant has, meaning the insurance, right? So if the defendant has $1 million, you can get $1 million. If he doesn't have any more, it's unlikely. You can go to court and get, $2 million, but then how are you going to get the other $1 million? Unless there's like bad faith or some way to get more. So usually, what you're suing for is just a function of what the person you're suing has the ability to pay you. And then strategy is also something, I think, this is why like an attorney really should be in contact with their client, because it's like an ongoing process. Strategy should be something you develop with the client. I mean, the strategy, if it's a complicated case or you have some kind of special strategy, that's something that, the attorney may have on their own. They may disclose some of it to you. They may not disclose some of it to you. If you want to know the strategy, you could ask them or have meetings with them, like Zoom meetings, video calls, phone calls, in-person meetings. So Yeah. And then somebody else says, your question makes me sad and mad. What other area do we even ask for this basic information? Lawyers need to keep us informed if they change strategy. Lawyers can be so awful towards clients, arrogant and dismissive. Lawyers need to be easily sued for their malpractice. Then we may get decent treatment. Arkady shines a light to a more equitable future. Yeah, I mean, thank you. I mean, yeah, I agree. Lawyers do have to be accountable. I mean, the worst thing is if somebody's like, the lawyer just should be transparent. If he doesn't think the case is successful, they should just tell the client, or maybe like if they feel like they're not the best lawyer to handle the case, they could refer the case to someone else or partner up with someone. Then make it stronger because now you have a better legal team. Now, of course, that means they might get less money, right? So not everybody's going to want to do that, but if that's what's in the best interest of the client, that's what they should do. And someone else says, the only reason I ask Mr. Frekhtman so many questions is because my lawyer literally sounds like they hate talking to me ever since I rejected epidurals. And they just give me the cold shoulder. They never answer my questions, and I'm almost scared to even ask them questions. Yeah, that's not good. I mean, yeah, lawyers should be in communication. I like this. Yeah, I remember this person, he was talking about not doing epidurals. I don't think that's such a huge deal, not doing epidurals. I mean, he may want to do something else. He may not. But the lawyer should still, I mean, it's like you're a professional, right? So you have to take care of the client. Like you're a doctor, right? You might think, hey, this patient needs to do this procedure. But if the patient doesn't do the procedure, as a doctor, you still have to treat the patient. You can't just, I mean, you may not make as much money because you didn't do a certain procedure, but then you can't just give the client the cold shoulder. That's not right. Let's see what other questions we have. I think this is also a question from the lone man, but I think we answered this pretty much in the last video where he's talking about a major accident in November on the Palisades. An SUV on the southbound side crossed the grass median and hit him head on at 70 miles an hour. That's just terrible. So liability sounds like 100% against the defendant. He was driving for Uber with a passenger, and they were both taken to the hospital. The passenger needed surgery. He's 24 and suffered a herniated disc, a bulging disc, and another herniated disc in his neck. The first one was in his lower back. He had radiculopathy, which is a traveling or radiating pain. From the neck, it goes to the arms. From the lower back, it will go to the legs. A concussion and damage to the right shoulder. Major damage to the car. It was labeled a total loss. And then the crash was on the news. So he's been doing a lot of treatment, but he rejected epidurals. And then it's a $1.5 million policy through Uber, not including his policy, meaning the defendant's policy. So yeah, we'll definitely find out what the defendant's policy is. And then if you can get additional through Uber, that's even better. But I don't think rejecting, his question was, I think, pretty much the same. I think we talked about it in the prior video, whether rejecting the epidurals would really hurt the case. I don't necessarily think so. I don't really, like I said before, I don't really like epidurals so much because all they're really doing is putting medicine on a problem, but they're not solving the problem. So if you have the herniated disc in your spine, the disc is exploded, right? And the liquid inside the disc is leaking outside the disc, touching those nerve roots. Now those nerves, there are big branches, it's like a tree, right? And then there's smaller little branches, and they travel all throughout, right? So that's why the pain moves. It goes to your arms through all those branches. It goes to your legs through all those branches, down to the endings, the nerve endings, which are the small nerve fibers. So that's a serious injury. Now, what you're doing with the epidural is you're just putting a steroid medicine on it. So it's just basically blocking the pain temporarily. But then, if the problem is there, that leak in the disc is there, the epidural is not going to solve the leak. It's just going to give you that temporary relief. Then the epidural wears off, the steroid wears off. So it's like taking Tylenol for a headache. But then the pain's going to come back, right? Because you have this exploded disc with the liquid leaking out. That's the problem. So there's other procedures like a percutaneous discectomy where they actually try to decompress the disc and remove the leak. That's a better procedure because it could help you and solve the problem. Then you don't have the pain anymore. Or, you know, if that's something the doctor thinks will help you. But that's something you have to speak with the doctor. Let's see what other questions we have. Reginald Hall says, I herniated a disc on my job when I had just turned 20. I had surgery and I was okay for 7 years until the opposite side of the disc herniated. So I had a second surgery. Then 6 years after that, the disc collapsed, leading to a third surgery, a spinal fusion. My workers' comp settled on the initial injury, but they remain responsible for medical bills totaling over $750,000. Now they want to settle on the medical portion, but I have no idea how I could put a number on what it's worth. So I would definitely speak to a local attorney, you know, who specializes. Because if this is straight workers' comp and it's so old, you would probably need a workers' comp attorney. I don't do straight workers' comp. I do the third-party lawsuits. So, but I know a lot of workers' comp lawyers here in New York, or if you're not in New York, if you're somewhere else, you could text me. Maybe I can help you find a qualified workers' comp lawyer. But that's what I would say. Have somebody help you. Don't try to do it on your own, because that's a big, big case with all those surgeries. And then Abed says, the lawyer that you really feel he is family. Oh, thank you so much. That means a lot. I'm glad that people are enjoying our channel and we're helping them. And then H. Chambers says, another question. Great video as always. Question, how severe must a personal injury case be to qualify for collecting $1 million homeowner premises liability policy? I just received back surgery for a herniated disc and getting shoulder surgery in June. Both injuries came from getting hurt from the homeowner's negligence. I slipped and fell from a non-bite dog attack, chase while at work as a UPS driver. Would those surgeries and injuries be enough to collect the entire $1 million? Yeah, I mean, I think so. If you had a back surgery like a fusion, that's usually enough to get $1 million, especially if the liability is strong. So if, like, you feel and your lawyer feels that the liability is strong, that this dog was chasing you, that the homeowner should have protected or kept the dog, away from you. It was a dangerous dog that maybe bit other people or chased other people, and then you had this slip and fall. It was not your fault. They were negligent. So now you've established liability. Then it becomes, hey, what is this worth, right? Let's put a value on this. What is just and fair compensation? Because to compend, right, compensation comes from compend. Compend means to balance. So they gave you these harms. Now what do they have to do? They have to balance the harms by paying you money to try to put you in the same position that you would have been in had this not happened, right, with money, which is hard to do, but it definitely could be worth $1 million. I mean, $1 million is not really that much money because you have these serious injuries. But I have to know a little bit more. Oh, she said it was a microdiscectomy and a laminectomy, and it happened in Illinois. Yeah, definitely. I mean, Illinois, I'm not too familiar with Illinois, but I know like there were a lot of big verdicts in Chicago if it happened near there. And the laminectomy is definitely a serious injury. So it could definitely be worth $1 million. It's definitely possible. And then somebody says, I got a concussion at a hotel. That was many weeks ago. I'm still having concussion issues. Yeah, so you definitely need to get a neurologist who's familiar with TBI. And she says, I don't know what a TBI is. Okay, so TBI is traumatic brain injury. So if you're having symptoms like that, then definitely, I'll even type it in. Yeah, definitely get that checked out. Then someone says, I don't understand why pedestrians who are jurors have a problem with big rewards for the injured? Is it because they think they are paying most of it from pittly taxes they pay or something? Or is it more like religious or belief stigma? Well, I don't know if pedestrians in general have a problem. I mean, like, everyone's a pedestrian, so I don't think it's a pedestrian issue. I think it's more like the specific individual and their system of beliefs, right? Everyone kind of comes in to, let's say you get called for jury duty. So you're coming there to the court with who you are, all your experiences, all your beliefs, and also maybe your future, right? Who you want to become in the future. And you could be coming, on different days too, right? Sometimes you could be like a little bit depressed or upset about something. Maybe something's going on in your personal life. Other times you might be really, in a good mood or just in a neutral mood. So it's a lot of different things at play. So I think the important thing there is for the lawyer to be able to do a really deep dive, probing voir dire. Voir dire is the jury selection where you ask a lot of questions, but really not spend too much time. The lawyer shouldn't spend too much time talking. The jurors should all be talking to each other, to the lawyer, get interaction. And then you get a sense of who will be a good juror for you. And if the juror says, like I asked the jurors, like in my last case, the one that I got $535,000 verdict, I asked in the voir dire, I said, if the evidence in the law justifies and you see that this is a serious life-changing forever injury and it could be worth more than $1 million, do you have any issues allowing for $1 million? And then some people said, yeah, I don't want to allow that much money because I just feel like people are fakers. So, you get those people off the jury. You get them off for cause. That's a cause challenge, right? Because they can't be fair. Now, if the evidence in the law does justify it, right, they can't follow the law and allow for $1 million. So you get them off. So you have to be able to do that. And it's kind of like an art. It takes time. Like, I'm getting better at it. I'm still learning myself. I watch other lawyers. I do a lot of like continuing legal education. It's not easy. And I think I've gotten a lot better. Like in the beginning when I was doing the voir dire, like I remember my first jury trial back in like 1999. I just got up there, I had my notes. Somebody said, this is what you ask it. And they would just do things based on stereotypes. They would be like, are you a homeowner? Yes, I'm a homeowner. Oh, okay. Oh my God, you own a home, but I'm suing a property owner because I have a ceiling collapse, so I have to get you off. But that's not really the best way to do it. The best way to do it is really ask them about all these questions and just be honest with them and see if they can allow for these big verdicts. And actually, in my last trial, I was actually pleasantly surprised. A lot of the jurors couldn't even understand the concept because they said, like, look, they understood like the value of not being able to do what you love to do. Like if you are, let's say, a parent and you want to pick up your kid and throw them in the air and catch your kid, and you can't do that, right? That's value, right? And they understand that you can't put a price on that. That's priceless, right? Like kind of like that credit card commercial. For everything else, there's MasterCard, but some things are priceless. And this is a priceless thing. And then another analogy that I use sometimes, or metaphor that I use, is like diamonds, right? Imagine all the diamonds in your life, things that you love. And this could be going to the beach or traveling or being with your significant other, being with your kids. And imagine like all those diamonds were put in a bag and somebody took the bag and just like threw it away. Now all those diamonds are gone, right? What are those diamonds worth to you? So I was trying to like, get a sense, because a lot of people say like, oh, money's not going to help. What good will money do anyway? And all these kind of defense, arguments. So I kind of said, well, imagine this was like an airplane and the airplane got destroyed and it was like a $20 million airplane. Would anybody have a problem putting a value on it? If we showed you the blue book, would you have a problem, if somebody negligently destroyed the airplane? Now the airplane's gone and nothing left. It's all burned to a crisp. Anybody have a problem, allowing for 20 million, right? Because we show you. No, nobody has a problem with that. But what if it's the same thing, but now it's a human life? Does anybody have a problem? And actually, my jury pool was pretty good. They said that they don't have a problem with that. And I almost felt like, I'm bringing up problems when I should have just shut up. So I had a really good, but a lot of the times in more conservative places like maybe Texas, Oklahoma, I don't know, other parts of the country, you will have the counter argument. So, so that's why, their beliefs and their ability to allow for monetary compensation, that's something you have to do in voir dire. That's really important. And then Tony says, my MRI shows a bulging disc. And I said, look, a bulging disc, that's an injury that could be compensable, meaning it's a diagnosable injury. And he says, I hope I can make this guy pay because it's a hit and run. So if it's a hit and run, but you have proof that he hit you and he left, you may be able to, now you don't know who, his insurance, right? You don't know his plate, you can't sue him. You maybe can do, again, UM arbitration against your own policy for your car. See here, what other questions do we have? Richard Vara says, great channel, very, very informative. Thank you so much. I appreciate it. And then Deborah says, I got a bad staph infection after a cervical spinal fusion, fused from the C1 until the T2. So C1 is the cervical, right? So you have the cervical, the first vertebrae. I'll show you on a model. Well, this is actually the lumbar. This is the lumbar, but the cervical just gets smaller. It's at the top. But the point is that that's a large fusion because you're doing C1. C, I think, goes all the way to C6 or even C7. And then after that, you have the T1. The T is the thoracic. That's the middle back. So that's a large fusion. That's like a 7 or 8 level fusion, a T2. Wow. So I'm wishing you a speedy recovery and the best of health. That's terrible that happened. But I guess infections are something that sometimes they happen as a risk of the procedure, and sometimes they could be due to negligence or medical mistakes as well. And Black Powerful says, hey, my friend, what if the first offer is $1 million and your lawyer turns it down? Do you think the insurance company would go up to at least 1.9 million? I mean, it's hard for me to say. It's possible. I mean, it's a good sign if the lawyer is turning down $1 million. That means the lawyer thinks that the case is worth more than $1 million, and it also means that there is, the ability of the defendants to pay more than $1 million. So that's definitely a good sign. And wishing you all the best, getting the best possible result and full justice, absolute full justice for your case, because it sounds like you have a good case. Then the King of Wings says, we were hired by an apartment complex to work with our food trailer. While we parked on their property, we were hit by another motor vehicle, totaling our truck and damaging our trailer, resulting in us having to go to the hospital with back, shoulder, and neck pain. Is the apartment complex liable for our injuries and our lost wages? I mean, I think primarily it sounds like the other vehicle is liable, because if you're parked and they're hitting you, so obviously they're at fault, they're negligent. The complex, I mean, you could potentially be liable, but you'd have to show what the complex did wrong. Because if you just parked, let's say, in a complex parking lot and, somebody comes in there and hits you, I don't think the complex is going to be liable. They're going to say, well, it's just a parking lot. Nothing is wrong with the parking lot. They just kind of it was the location where it happened. They furnished the occasion for the incident, but they didn't cause the incident. Nothing they did wrong or negligent was the cause of this incident. So it sounds like probably you're going to have to go after the car. But I mean, in some conceivable way, I could see the, a complex, if they did something wrong, you'd have to tell me more facts. If they, for example, had the food truck set up in a roadway or somewhere unsafe where cars were going, and then he hit you because he didn't know the food truck would be there, something like that, then possibly then it's on them, right? Because why did they put the food truck in an unsafe location? But you have to show that they did something wrong. Okay, let's see what other questions. CB says, how do I get in touch with you for a case involving a TBI? Oh yeah, for that, just feel free to text me, 347-566-9595. And then Philip says, what does it mean when the defendant's lawyer seeks a settlement demand from your attorney? My case or lawsuit has 4 defendants and only 1 has made a settlement demand. What's your call on this type of legal position? So what I think is, usually what it may be is you're suing, say 4 or 5 different people. And then one of the people might think, we're at fault. what's the point of us litigating this? Or their insurance company might be, pressuring the defendant. Hey, why are we paying all these bills? Now you got to go through, do 5 more depositions for all the parties. Why don't you try to get out of the case? Why don't you settle? But you can't really do that. At least in New York, you can't, because there's a general obligations law, and you really have to settle globally with all the defendants. And it doesn't, very, very rarely, especially in a big case, doesn't make sense to settle with only one defendant. So then what happens is you just have to, you basically just have to send your own letter. Your attorney should send your own settlement letter to the defendants and say, look, my settlement opportunity is for this amount. Pay this amount within 30 days. And if you don't, then it's going to go up, and put the pressure on them. Then they could all talk to each other. Because if one of them has a settlement offer for you, there's no reason that he can't call the other defendants, co-defendants, and they can come up with a package for you all together. If they're going to do that and be fair, you could also schedule a mediation once you have like an offer that's fair. You say, look, okay, I want like $1 million, but they're giving me like 300, but I see that they have the room to move. Let's go to a mediation, and maybe you settle the case, right, at the mediation. But if it's just one defendant and everyone else is like no pay, then I think you just have to keep going with the litigation. Okay. And somebody asks, what if it's federal? Yeah, federal cases, it could be a little bit tougher, to be honest. I think I talked about this also in a prior video. It's because sometimes the federal judges don't allow attorney voir dire, or they really limit the attorney voir dire. So like we talked about, voir dire is so important, but you get to understand the potential juror's belief system and everything. Now, what if you can't ask any questions, right? Then it's almost like the judge is just going to read off a boring list about like certain questions, like, and then just pick people. Then it's almost like the first group of people that you see on the street, that's your jury. Who knows what they're going to do? Then it's like flip a coin, So I don't do too many federal cases, but federal I think is harder than state court. And then someone now, Ms. Mills says, "What? My case is in litigation. What does that mean for me?" So being in litigation just means that a lawsuit was filed and that the case is moving along, and you're litigating. Litigating is the act of filing a lawsuit, preparing discovery demands, responses, doing depositions. That's all litigation. It could be before or after depositions. And then when you stop litigating is when you actually resolve the case. So resolving the case just means that you settle the case, or that you get a judgment, that the case goes to trial. I mean, of course, there could be other ways, like if you settle and you sign a stipulation of discontinuance, you discontinue. Now, it's not litigating anymore, it's discontinued. There's a bunch of different ways, but usually it's either a settlement or a judgment. It could be a summary judgment, meaning that they won, or they got it dismissed for whatever reason, but it's some kind of disposition or resolution. And then I think Ray also is having trouble with that lawyer again. He says he doesn't know the policy limits, and he's upset. So I told him to text me, and we could maybe try to help him. And then somebody says something about going to Brooklyn court. I'm not sure what they're talking about. And then finally, Araf says, usually what percentage or how many cases go up on appeal, at least in your career? A lot of the big verdicts I see go up on appeal, especially in New York. Yeah, I mean, definitely a lot of the bigger verdicts. I mean, I think as a percentage, I think few cases go up on appeal, probably like, less than 5%, because, most verdicts are more like normal, or most settlements, there's no real reason to go up on appeal. But the big verdicts, again, if you're getting like 5 million, 10 million, they're going to appeal that because they don't want to pay that. So they're going to take a chance. First of all, they get a delay. So they don't have to pay you the 5 million, right? They could leave it in the, let's say, stock market or wherever they keep their money, and it can maybe grow, even if they have to pay 9% interest. But, and then they have the big chance that the appellate division, which some of the appellate courts tend to be a little bit more conservative, right, than the trial courts. So they might say, this is too much money. Let's cut this down. So then they'll appeal because of that. So definitely something that happens. I guess the more heavy or big the verdict is, the greater the chances of the appeal. Okay, I hope this has been helpful. I think we're up to date now, which is good. Maybe the next time we could do a live and you guys could ask your questions. We could try to answer in a live video. So thank you for watching. Please like and subscribe to our channel. Ask us questions, leave your comments. And if you have a specific question, just text me and we are here for you. Have a great day, everyone. Stay safe out there and we will talk to you very soon. Okay, bye-bye.